Hosting today's CLE at George Mason University School of Law, whose support we're very thankful to have both for past CLEs and for today's. For those of you who have not heard about the Immigrant Outreach Committee before, its primary objective is to educate Virginia lawyers regarding the immigration consequences of criminal convictions. One of the most effective means to fulfill this objective is to host CLEs like this one, at which Virginia lawyers like yourselves can receive important training relevant to your immigration-related practices, as well as a network with other Virginia attorneys. On the horizon, we're planning a CLE aimed at promoting pro bono participation in the field of immigration law. If any of you are interested in any of the above, the committee is always looking for volunteers. So please email either myself or my fellow co-chair, J.D. LaCruz. One of the email addresses listed on the first page of your course materials. And one final note before we begin, the CLE is being video recorded by the Virginia State Bar and will be available to view online. We encourage you to rewatch the course presentation for a refresher, or for those of you who did not have a chance to attend today's seminar, to watch the presentation for the first time online. Also, be sure to take advantage of the Young Lawyers Conference's extensive presence both on the internet and on social media, including at vayounglawyers.org, as well as on YouTube, LinkedIn, Facebook, Twitter, and much more. So without further ado, we'll start with our first session for the day, titled Avoiding Grounds of Deportability. Unfortunately, one of our panelists for the session had to cancel. Fortunately, however, her co-panelist, Jonathan Bialosky, is here with us today and is well prepared to present the topic. Mr. Bialosky works as an attorney at the Immigration Clinic at George Washington University School of Law, where he supervises law students representing asylum seekers and respondents facing deportation in immigration court. He previously served as director and immigration attorney at the Maxwell Street Legal Clinic in Lexington, Kentucky, and is an honors graduate of George Washington University School of Law. During law school, he completed an internship in the Helsinki Citizens Assembly Refugee Advocacy and Support Program in Istanbul, Turkey, where he provided legal assistance to refugees from the Middle East and Africa. He also interned at the U.S. Committee for Refugees and Immigrants, the Migrant Legal Action Program, and Amnesty International in Washington, D.C. Please join me in welcoming Jonathan Bialosky.
Hi, good afternoon.
Is this on? Okay. I'm going to start sitting down, if that's okay. I don't have a PowerPoint, so I'll use these materials that were provided to you all. Again, my name is Jonathan Bialosky. I work at the George Washington University Law School Immigration Clinic. I'm an immigration attorney, and I'm going to be handling the first portion of today's presentation, avoiding the grounds of deportability. So in many ways, this is going to lay the groundwork for the later segments. And so for that reason, this is also in many ways very sort of basic. So apologies for that. Along that line, I'd like to sort of start off and get a feel for what it is that you all do. We were talking to some of the panelists earlier, and we're not really sure who's in attendance today. So some of you may be very familiar with these topics, some of you not so much. So if we could just kind of maybe briefly sort of show of hands, or maybe even go around. Are any of you immigration practitioners in the audience? Okay, great. Be more critical of my section anyway. The rest of you, are you criminal defense or prosecutors or criminal attorneys? Okay. Any other sort of wild cards? Just interested? All right, excellent. Well, thank you all for coming. This is, as I said, my section anyway will be sort of a primer for the later sections. And for those of you that do this work, either on the immigration or criminal side, I apologize if it's too basic for you, but please bear with me, because I think a lot of people can stand to learn from some of these more basic topics. So that's what I'll be focusing on today. The title of my section, and again, like I said, I don't have a PowerPoint, so I'll explain the materials and how we'll go through them in a minute, but my section is Avoiding the Grounds of Deportability. I want to highlight the title, Avoiding, because this is all information that you should keep in mind before any sort of immigration enforcement happens, and ideally before any kind of criminal prosecution or certainly charging or trials or sentencing happens, because in many cases, as the immigration practitioners will know, after the criminal side of things, there's oftentimes not a lot that you can do for a non-citizen with criminal convictions. So this is all stuff to keep in mind on the front end. My main goal today is to give you guys the information to sort of keep these concepts in mind going forward, especially as you advise your clients before any sort of plea or any criminal activity. As you know, there is a duty on the part of criminal defense attorneys to provide non-citizens with information on any potential immigration consequences of any pleas they might take, and certainly any convictions. That comes from the Padilla v. Kentucky case in the Supreme Court, 2010. Maybe my standing here to give this presentation is I'm a licensed attorney in Kentucky, so I'm not licensed in Virginia, Maryland, or DC, so unfortunately I'm not going to be able to advise you on any specifics of those state laws, but I am licensed in Kentucky, so that's a fun fact. I didn't intend it to be that way, but worked out that way. There are probably some differences in Virginia, for example, state laws that I might ask you to help illuminate the other attendees, so we can maybe talk about these issues and how they'll play out in these jurisdictions. So please bear with me with that. But again, I'll be focusing mostly on the federal side of things. And as I said, my main goal here is to get you thinking about what you can do to help individuals avoid these grounds of deportation before they even become an issue. In the packet here, you'll see there's two numbers, at least on my section, one in the middle, part of the footer at the bottom here, and the one in the right corner with the CLE. We'll actually be going by the CLE numbers. There are a few documents I'd like to actually have you look at while I'm speaking, because I think it'll be easier, and when I reference them, I'll use the CLE code in the bottom right. So thanks for that. Sorry for any confusion. If we could, at the risk of being sort of very juvenile, we're going to go through some of these documents. So starting off with CLE 3, this document here will be familiar to those of you that are immigration practitioners. For those of you who aren't, it might not be, but this is a certificate of naturalization. This is a document that shows that this particular individual, actually it's my boss's mother, rest in peace, Mrs. Benitez is no longer with us, but this is a document that shows that she, as someone born in another country, in this case Mexico, naturalized to become a U.S. citizen. And I've included in the materials today, with my boss's permission, of course, to show that it's always important to figure out who it is that you're dealing with. Figure out someone's immigration status, and there are a variety of different immigration statuses, citizen being sort of the best one or the strongest one. We often don't think about it, but for example, I am a U.S. citizen. Many of you probably are too. I don't want to make any assumptions, but U.S. citizen is a type of immigration status. It's the #1 immigration status we can have in this country, but obviously we don't really think about it on a daily basis or walk around with any proof of that typically. But this document here, the Certificate of Naturalization, is the type of proof that those born abroad and who've gone through the naturalization process would have to show that they too are U.S. citizens. And so if you ever see this, that's a great sign. If you ever see things that show that someone's a U.S. citizen, you don't have to worry about any consequences of any criminal convictions in the immigration context, because as you all know, if you're a citizen, you can't be deported. So that's great news. So this is something to keep an eye out for: a certificate of naturalization, a U.S. passport, a birth certificate showing that someone is born in the United States. Those are all forms of proof that someone's a U.S. citizen. As I said, there's other immigration statuses. The most common or prevalent one probably that you'll be dealing with being lawful permanent resident, individuals with green cards. That's sort of one step below, and you hear the term green card sort of in colloquial speech, but it's actually a legally accepted term, green card. So if you have an individual who's a lawful permanent resident, the proof of that will be his or her green card, which now is actually tinted green. It's a plastic card that looks like a driver's license. One sort of myth is if you've got your green card, you can't be deported, and actually that's not true at all, just the opposite. So some of the more complex cases you have might involve people who have been granted their permanent residency and have their green card, but are facing these severe immigration consequences. So the point of this document here, again, is to get you thinking about what is your client or what is the individual you're dealing with's immigration status. And if they're not a citizen, then you really have to consider these immigration consequences of any sort of criminal plea or conviction. Flipping along, again, we'll get this sort of juvenile stuff out at the beginning, but on page CLE 4, I've got an excerpt here from the INA, which is the Immigration and Nationality Act. This is the singular statute that governs the vast majority of our immigration laws in the United States. The INA is a civil law, and it has provisions in there for all sorts of various and sundry immigration benefits and consequences and enforcement that the government can take against individuals. And in this excerpt, section 101, these are the definition sections. I've got not redacted section 48, which defines the term conviction. And as I said, this is going to be a little juvenile, but I'm actually going to read it out to you word for word, because this is essentially the cornerstone or building block of this whole topic of the intersection between immigration law and criminal law. So, page CLE 4, the non-redacted part 48A says, the term conviction means with respect to an alien, a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where a judge or jury has found the alien guilty, or the alien has entered a plea of guilty or nolo contendere, or has admitted sufficient facts to warrant a finding of guilt, and the judge has ordered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. I'll stop there for now before we get to subsection B, but this is very important because when we use the word conviction in the criminal law context, or sort of in everyday speech, it has a specific meaning that's sort of generic. We think, oh, conviction is a conviction. We don't really think about it too much. But in the immigration context, what a conviction is, can, and often is different. So if we go through this, the first part says conviction means with respect to an alien. Alien is someone who's not a citizen of the United States. So again, that goes back to the first point, that someone's immigration status is vitally important. We're talking about people who are non-citizens. So in the example before, the certificate of naturalization, Ms. Benitez, I don't even know her first name, Ana Maria, she is a native of Mexico, so she's now a citizen of the United States, so she's no longer an alien. Aliens are people who are not citizen, even though that's sort of a weird sounding term, aliens. With respect to an alien, a formal judgment of guilt of the alien entered by a court, that's sort of the traditional conviction. So you're found guilty at the end of a trial or another type of hearing. But then we've got this other clause, or if adjudication of guilt has been withheld. So no adjudication yet, not a finding of guilty by a judge or a jury, where these following two conditions, and there's an and here, so they both have to be met. Where, one, a judge or jury has found the alien guilty, or the alien has entered a plea of guilty, or nolo contendere, or has admitted sufficient facts to warrant a finding of guilt. That's part one. So again, we see it can be a finding of guilt by a judge or jury, or it can be a guilty plea, or it can just be an admission of sufficient facts. So these are all things that don't really fall under the umbrella of conviction when you think about that term in an everyday sort of usage, but they can result in a conviction under our immigration law. So that's the first condition that must be met. And then there's the conjunctive here. And part two is the judge has entered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. So some kind of punishment. And I can tell you that that has been interpreted to mean anything at all. It can be a fine, can be probation, any sort of restraint means any sort of restraint. So we've got this here. It'll either be sort of a conviction in the traditional sense, which you're normally thinking about, or it could be a plea of guilt and then some restraint on liberty, or it could be an admission of guilt and some restraint on liberty. As I said, it could even be a fine or probation. So these are all, this is a broad definition for what conviction is. And going forward under our immigration law, you'll see as we go through these materials that you need to have a conviction before any of the consequences really take hold. But what a conviction is a pretty low bar under the statute here. So that's why I wanted to read that. By the way, if there's any questions about these materials, we talked a little earlier about saving them for the end might be an option, but if anything comes up, quite frankly, it might be easier to just field the questions as they come up about these. slides or these materials. So feel free to ask any questions. So conviction is subsection A of this number 48 of these definitions of what does a conviction mean, and it's different in immigration. I want to talk a little bit about Part B too, because this has to do with sentencing. Sometimes in immigration, consequences of a conviction are dependent upon the sentence as well. So the timing imposed is an important factor to consider as well. So this subsection B references what that means, term of imprisonment. So subsection B, any reference to a term of imprisonment or a sentence with respect to an offense is deemed to include the period of incarceration or confinement ordered by a court of law, regardless of any suspension of the imposition or execution of that imprisonment or sentence in whole or in part. So what does that tell us? Any term of imprisonment can mean anything that's imposed, whether or not part of it's suspended. So if you get a 12-month sentence and 11 months is suspended, for immigration purposes, you've got the 12-month sentence. And as I said, going forward, that'll come into play. Oh, are we able to do this? Oh, excellent. That might be easier. Then I guess I can scroll through here. Man, this is great. So yes, it's important to keep that in mind. Of sentence, for all intents and purposes, doesn't really do too much for your client in the immigration context. So keep that in mind. So this is sort of the building block that we'll use to go forward. What's a conviction, and what does it mean in immigration law, and how might it be different from the sort of traditional conception of what a conviction is. So keep this in mind as we go forward. Before we move on, I'd just kind of like to ask, for those of you practicing in Virginia, can you think of any dispositions or outcomes where it might sound like a good deal on the criminal side of things, where someone isn't technically convicted criminally, but under this definition here, they would be subject to a conviction under immigration law? Yes?
A suspended imposition sentence where a judge says this is a purpose, guilty, and then dismisses when probation is.
Exactly right. And most states have some variation of that, like a deferred prosecution, or because I'm not licensed in this area, I'm still kind of learning the lingo. There's something in Maryland, PBJ, peanut jelly? No, probation before judgment. So that's kind of a similar disposition here. But keep in mind that if you don't enter a plea pursuant to this Roman numeral 1, the lowercase Roman numeral 1, if you don't enter a plea or don't have to admit any facts, but can get some kind of deal like this and don't satisfy condition 1, that might not necessarily be a conviction. So advice to criminal defense attorneys is, take the imposition of any sort of sentence or penalty, but if you don't have to make any, admit as little as possible, and don't plead if at all possible. Some states have ways to do that. I don't know if that's an option here, but yes. Yes, it depends. I guess if you have to admit sufficient facts to make the Alfred plea, that might constitute a conviction. But if not, if it's pretty sort of vague and generic, then all the better. There's some litigation in the immigration law world whether or not Alfred pleas count as conviction, and it's all very fact specific and case by case. So, yes.
Would this apply in civil cases where it's like a tort and someone, they're admitting that they did something wrong and they have a jury finds them liable? Would that count as a conviction?
No, civil liability doesn't count. But that's a good question. Okay, I'm going to go to the next section now, which has to do with how can convictions result in deportation for non-citizens. Okay, I'm sorry. Okay, sorry. Well, I'm on number 5 here, CLE 5. This is the subsection of our Immigration and Nationality Act that talks about the ways that people can be deported or removed from the United States. We've got the section highlighted here on CLE 5 about criminal offenses. So this governs the ways in which that people who have committed criminal offenses, been convicted, are then subject to immigration enforcement, which means deportation. So this section outlines the grounds of deportability, the criminal grounds of deportability. And I've got this section highlighted here, excerpted actually in full. It actually goes on the page. 7, CLE 7. So I'm not going to read through this entire subject, don't worry about that. I think most of my reading to you is done. But I do want to highlight 3 parts of this, which are under A, Roman numeral, lowercase Roman numeral 1, 2, and 3. These are the more common circumstances you'll come across when dealing with non-citizens and criminal issues. This first subsection on Roman numeral 1, lowercase Roman numeral 1, crimes of moral turpitude. This talks about people being deportable for having convicted crimes involving moral turpitude. And like I said, I don't practice criminal defense law. I'm not licensed here, but even if I were, I don't know that I would know what that term means. Crimes of moral turpitude. While the Immigration and Nationality Act does define conviction, unfortunately it doesn't define crime involving moral turpitude. So this is something that's made by judicial decisions. This is a term that's sort of constantly in flux. We don't really know what it means. What we do know is that if someone's been found to have been convicted of a crime involving moral turpitude, you can see here if it's been a crime of which a sentence of 1 year or longer may be imposed, that person is deportable. So crime involving moral turpitude is just sort of the lingo to keep in mind, but there is no definition. But I can tell you, generally speaking, any sort of theft offense is usually considered to be a crime involving moral turpitude. Any kind of fraud-related offense. The physical offenses, sort of assault and battery, need to have sort of an intent element. It can't be something that's just sort of reckless. It needs to be something more than reckless, some sort of intent to commit a crime. But crime involving moral turpitude is not easily defined, and we could easily have a whole CLE on what is a crime involving moral turpitude. But number 2, uppercase Roman numeral 2 is important. You can only be deportable if it's a crime for which a sentence of 1 year or longer may be imposed. So in Virginia, does that mean felonies? Felonies are defined as offenses for which...
Last one, misdemeanor is 12 months as well.
Okay. So I didn't know. So keep in mind the maximum possible sentence, because this says a sentence 1 year or longer may be imposed, not necessarily was imposed, but may be imposed. So if you're looking at a crime, one easy way to screen these out is if you're looking at a crime to see if a conviction of that crime is a crime, counts as a moral turpitude crime. If you could be sentenced for a maximum of only 6 months, you're in luck, because you know this condition under uppercase Roman numeral 2 isn't satisfied. Lowercase Roman numeral 2, forgive me for having to go back and forth, this is part of the problem of immigration law. The statute is so dense, but multiple criminal convictions talks about convicted of 2 or more crimes involving moral turpitude. So it's the same sort of concept, but it has to do with sort of recidivism. Lowercase Roman numeral 3, aggravated felony. This is another term of art, but thankfully, as we'll get to later, there is a definition of aggravated felony under our immigration laws. It's not necessarily a felony at the state law level, has a specific definition within the Immigration and Nationality Act, but aggravated felony is sort of a worst case scenario for a non-citizen. If you've been convicted of an aggravated felony, in many cases there's little, if anything, you can do to avoid the immigration enforcement, the deportation proceedings. So I wanted to highlight that so you have that in mind as we go forward. And as you go forward in your practice, any mention of aggravated felony is something you should sort of shudder at or run away from, because it's very, very bad and it's very difficult to provide any good assistance to those who have been convicted of aggravated felonies. I can go through quickly. CLE page 6. The following page has a controlled substances provision, firearm offenses, and then here at the bottom at subsection E, domestic violence. Those are 3 sort of biggies: controlled substances, guns, and domestic violence. If you've got a conviction of those are also ways in which non-citizens can face immigration enforcement and the removal process, the deportation process. These statutes, we're not going to read them, but you can see they're written pretty broadly. For example, the controlled substance convicted of a violation of any law or regulation relating to a controlled substance. I mean, that's pretty broad. There's very limited exceptions to these crimes. Same with firearms and domestic violence. So crimes involving moral turpitude, aggravated felonies, drugs, guns, and domestic violence. obviously not good ever, but particularly for non-citizens, they can have very, very harsh immigration consequences. Okay, let's get to the definition of aggravated felony if we could. It's on CLE page 8. This is, again, back to the section 101 of the Immigration and Nationality Act, the definitions part. We're at number 43 here. The term aggravated felony means, and then we have A all the way through U. So we've got here a list of potential criminal activity that's potentially an aggravated felony for immigration purposes. As I was saying a moment ago, if your client or an individual or you personally are found guilty or have been found guilty of a aggravated felony, you've got very, very limited options in the immigration context. So it's important to know what constitutes an aggravated felony. It doesn't necessarily have to be a felony at the state level. You might meet the definition of felony in the Immigration and Nationality Act where the crime that you've committed or been convicted of at the state level isn't necessarily a felony. I don't have an example for you offhand, but I know that's possible. A through U, these are actually sort of the easier ones to understand, because particularly for those of you that practice criminal law, because they're serious crimes and they're kind of written very plainly. So A, murder, rape, or sexual abuse of a minor. That doesn't bear too much explanation, sort of leaving aside the differences at state law for these offenses. This subsection here is written to encompass the various state law variations of these very serious crimes. So a lot of it has to do with drugs and guns and fraud and conspiracy and all sorts of very bad things. But you can go through and look at these A through U section, but keep in mind that keep in mind that these are bad situations for your clients. If they're non-citizens and they found guilty, convicted of these aggravated felonies, they're in bad shape. So one thing to keep in mind is, as you're advising people in the criminal defense context, is how can I avoid this being classified as something that might constitute an aggravated felony? How can I avoid something that my client's done or charged with being classified as a crime involving moral turpitude? So it's a very, very tricky issue. Even though I don't practice criminal law, I know it's a tough ask to go to a prosecutor or a judge and say, hey, I've got my client here who's done something, and if he's found guilty as charged, he's going to face some very serious immigration consequences. A lot of times the other side might say, why am I going to cut this guy a break when I wouldn't do the same for someone who's a citizen of this country? I know it's very difficult, but a lot of times the only option you might have is to try to argue for a lesser charge or a variation that's less severe, because anytime you get sort of boxed in these crime involving moral turpitude convictions or aggravated felonies, you're in very bad shape. And so if you call me or someone who's an immigration practitioner and say, hey, I've got this guy or this lady who's been convicted of X, we may very well tell you, well, I'm sorry, I wish you would have contacted me before you made that plea or before the trial, or contact me for some advice before this point, because there's not much I can do. So aggravated felony is a very, very important concept, sort of bad news bears. Worst case scenario for non-citizens. The one section I'd like to highlight here is F, subsection F, capital F, the crime of violence. This again is an example of why the immigration statute is very complicated, because this is a cross-reference to another part of federal law, another part of the U.S. Code where there is a specific definition of crime of violence. So to know what a crime of violence is, you have to go to this other Title 18, and see if the particular charge your client is facing or conviction that your client has meets the elements of that definition too. So again, it gets very complicated. You're going back and forth between various statutes or subsections. Any questions so far? We talked about sort of immigration status, conviction, and the various types of bad crimes. Yes?
Going to crime of violence, it says a crime of violence for which the term of imprisonment at least 1 year.
Yes.
Is that term of imprisonment imposed as at least 1 year? Or term of imprisonment that may be imposed as at least 1 year?
May be imposed. You see the little sick here? This is a poorly worded for which the term of imprisonment at least 1 year. Something is missing there, like a verb or something, but yes, it's possible sentence here. So, again, I guess the gentleman was saying that a Class A or 1 misdemeanor might be that in Virginia, and then felonies, it sounds like 2. So, possible sentence. Okay, I'm going to go on to, very briefly, CLE 11. This, actually, I didn't realize, but it'll be covered more in depth in the last part of our CLE. These are some forms of relief to prevent removal. I have it in here sort of like a cheat sheet, a quick sort of reference, but we'll talk about this in the third section of the CLE today. But if someone's facing deportation, and even if they're found to have committed, for example, an aggravated felony or a crime involving moral turpitude, there are various defenses to deportation. We call them relief from removal. And here's a little chart. And the important thing to keep in mind here is that each one of these things, for example, asylum is something you might have heard of, even if you don't know really what it is, but asylum is a type of relief from removal that a non-citizen has, and the government's trying to deport him or her. And it has its own statutory eligibility criteria that you have to meet to be even eligible for this, but it also has sort of criminal disqualifiers. And so all of these various options, you'll see there's 3 pages of them. Got things like these special visas, cancellation of removal is something that's relatively common. Each of these has its own eligibility criteria that someone has to meet, and then they face being screened out because of various criminal violations and convictions that they might have as well. So this is a quick reference guide. We're going to go much more into depth in this later on in the CLE, but you have it here as well. The bulk of the time then that I wanted to spend today will actually go on some sort of real life examples. So in your packet I've included some documents that we can kind of go through, like real life scenarios, hypotheticals, so you can get familiar reviewing some of these documents and picking out key things that will help you know what potential immigration consequences the individual might have. So I'm on CLE 14 here. This is page 14 and 15 go together. They're 2 sides of the warrant of arrest here from Virginia. And there's a couple things I'd like to go through with you. Those of you that do criminal law work will be familiar with these documents. Those of you that do immigration law might have become familiar with these documents, but for everybody's sake, let's just go through some key things here. I know it's sort of, oh no, you're able to get it rotated. Excellent. This, as you can see, a warrant for arrest. We've got assault and battery of a family or household member, mother, in Virginia. So we've got a violation of Virginia Code 18.2-57.2. Side 1 here, for those of you who aren't familiar with these documents, are sort of the facts laid out, and side 2 has the dispositional information. So page 1 is important to know what the crime is, how it's characterized. You've got the citation to the Virginia Code. So later on, if you're working with a non-citizen who brings you this document, you can go look up what the offense is, what the elements are, and if there's been a conviction, you can kind of see if a conviction of this crime based on these elements under Virginia law, things like possible maximum sentence, meets the definition of, for example, this crime involving moral turpitude or aggravated felony. So these documents are very important, and if you're practicing immigration law, you'll get very familiar very quickly with these law enforcement and criminal court documents in your particular jurisdiction. So front side, page CLE 14, we get the bigger, aside from the biographic information of your client, is the characterization of the charge and the citation to the code. Following page CLE 15, we've got how things turned out in the case. So you can see sort of on the far left column, we've got that the defendant entered a plea of guilty. Entered a plea of guilty. So we know back from our definition of conviction, even regardless of what happened after that, just entering the plea of guilty might still make this a case where there has been a conviction for immigration law purposes. So plea of accused, guilty, entered a guilty plea. Then we've got over on the following column toward the middle, jail sentence of 90 days imposed with 80 days suspended condition upon being of good behavior, and all the rest of that language. So we know here, left column says plea of guilty, middle column says there's been some imposition of a restraint on the individual's liberty or punishment. So we know back from our definition of conviction under the immigration statute that this is a conviction. Plea of guilty, not a finding of guilt by a judge or a jury, but a plea of guilty with some imposition of punishment. And we also know from that very same definition that the fact that 80 days of this has been suspended doesn't matter for immigration purposes. So if there were ever anything that hinged upon the 90-day mark of possible sentencing and the effects that that would bring, this guy, or this we'll use the male example throughout. I don't mean any disrespect to the males in the room, but that's what we'll do. This guy has, for all intents and purposes under our immigration laws, been sentenced to 90 days, regardless of the suspension here. So even if this looks like a relatively good deal on the criminal side of things, we know that this gentleman has been convicted of a crime. So if he's a non-citizen, he's facing the consequences thereof under our immigration laws. So I want to open it up to you all who do this type of work. Is there some other lesser charge or lesser degree that if you're a criminal defense attorney or someone advising this individual, you could argue for so that they might not face this situation if they're charged initially with this assault and battery? Any sort of, yes?
Ask for a general continuance, where there's no plea, just continue for a period of time. Sometimes there's an agreement between you and the prosecutor. It's not in the court record that your client will do community service or something along those lines in the interim.
Okay, and so if you go that route, do you have to make any sort of manifestation of guilt or any kind of admission of facts or any plea?
No.
Great, that's great. If you can do that and there's no admission of facts, there's no plea entered, then it's very, very likely that you don't meet the definition of conviction under the immigration law, regardless of any kind of probation or sentence or punishment, which is, the second prong of that definition.
Just as a caveat, the odds of getting out on a domestic violence charge are very slim.
Okay. I know, yes, in some cases, again, the issue of why would you treat someone who's not a citizen maybe more favorably than a citizen just because of these harsh immigration consequences is an issue with prosecutors. Virginia and Kentucky are very different. They're both commonwealths. I learned that. Both commonwealths. So maybe things are very different here, but I can tell you the South typically is not kind to newcomers, particularly Kentucky. I don't usually like to have a bad word said against Kentucky, but it was very hard to make these deals with prosecutors and judges and make the argument, and they were sort of like, so what? But if you can do it, great, because again, you just want to avoid meeting the definition of conviction. So another suggestion I might make, assault and battery, again, we talked a little bit about these sort of physical offenses, whether or not they might constitute these crimes of moral turpitude, and it's an open question. It's all very much dependent upon how the statute is written at the state level and what the elements are and what kind of intent there is. But for example, if there's a way to get sort of disorderly conduct or some other lesser charge that just sounds less bad, that again might be another option. If you can't avoid conviction, the lowest possible charge is always the best, obviously. So even if it looks like a good deal on the criminal side of things, keep in mind that it might be an immigration conviction. Yes?
And piggybacking off what you just said about the like something such as disturbing the peace, and you also want to consider the option. One, don't mention it is about immigration, because that's always going to get you nowhere.
To the prosecutor? Or
yes, exactly. Okay. Don't do it. Don't even mention it for that. But one of the things that you have going for you, if you can break it down to your client, is agree to more jail time in order to get the type of charge you want. Even double the jail time. Like they want 15 days or 30 days, which you have to do 15. Say, hey, we'll do 45 days if we can get this particular charge.
I'm not ignoring your question, sorry, just feedback. Can everybody hear without the...
Yeah.
Okay. Yes.
That is a good idea, with one qualifier, as always. You need to be careful that the situation you're in isn't such that when you say double the jail time, for example, you're not going. There are certain things in immigration law where if you go past a certain amount of time actually served, the crime cannot be waived or held against you. So that's something that's outside of the scope of our presentation today. But there's an exception for people who commit certain crime if it's, what's called a petty offense. And a lot of that has to do not with just the classification of the crime itself, but the actual sentence imposed. So that is a good idea, sort of generally speaking, especially if you're talking about situations like this where it's 15 to 30 days, like you mentioned. That's less severe than if we get into sort of 6 months to 12 months. Great advice, but always make sure you know the facts of the particular situation you've got and how it might play out in immigration. But great advice. Thank you both for all the advice in the state law context. So again, keep in mind what sounds like a great deal on the criminal side of things might have very severe consequences in immigration court. Do you want to turn so over here? We're going to go to CLE 16. Next one. Okay. It's another warrant for residency. Glaringly, the big difference here is that this is a felony. Again, just because that's a state law classification doesn't necessarily mean much in the immigration world. Very well may, but that's not the end of the inquiry here. So look here on page 1, you see this is assault and battery. It looks like of law enforcement officers. We've got a citation here. It is classified as a felony. So we know to start off with this is good. I don't know why it's actually down. Let's go up here and keep going forward. This is a felony, so not looking good even to start out with before we sort of begin our analysis. Next page here, got the disposition here. More bad news. We've got the plea of the accused. It's a guilty plea on the far left column there, toward the bottom, and then he was tried and found guilty of assault and battery. So not good, not good. The middle column here, we find the sentencing information. There's a jail sentence of 12 months, 8 of which has been suspended. I don't know if that's a good deal for this particular charge at the state level, but again, maybe a good deal. Sorry? He avoided the felony. Great, great. Well, we know from our definition of conviction in the immigration law world, he's been convicted of a crime. The maximum sentence here, or excuse me, the imposition of the sentence here was 12 months. Regardless of the suspension, he's convicted of a crime, sentenced to 12 months for immigration purposes. So, determined, dependent upon the classification of this particular offense, he might be in pretty bad shape despite the favorable outcome at the criminal level. Yes?
Does it help that the box where it says the plea was voluntarily and intelligently entered is not checked?
It might, and we're going to talk a little bit about post-conviction relief in the second section today. So if I could sort of defer that question to that portion of the CLE, do that. So, great question, great question. There might be some post-conviction options. Do you mind to have some spot? I'm happy up here. Everybody's cool with me, sort of standing for you. Let's go on to the next page. Okay, those of you who were familiar with the last couple of documents, who practice Virginia state law, criminal law, might not be familiar with this document. This is an immigration document. This is a charging document in the immigration law world. So, sort of like the indictment in the criminal context or the complaint in the civil law context. This is called a notice to appear. See at the top left, if you can see, or if you have in front of you, this is a DHS document, Department of Homeland Security. Those guys in DHS play the role of sort of like Commonwealth attorney prosecutors in the immigration law world, particularly the Office of Immigration and Customs Enforcement, ICE, is housed under DHS. They're the prosecutors in the immigration law world. So this is their charging document. See, notice to appear in removal proceedings under Section 240 of the Immigration and Nationality Act. That's the same statute we were referencing earlier for the definitions. That part of the section governs enforcement and removal of aliens. So, placed in the proceedings, this is the charging document, notice to appear. I want to go through several things here. Obviously, the personal information is redacted, but under the word notice to appear at the top right, a little further down, you see file number A and a redacted part, and it says 024. That is what's called the A number. Many of you might be familiar with certain immigration practitioners, maybe some of the criminal practitioners. A number or alien number is an identifier that the Department of Homeland Security uses to identify all people who are non-citizens, even people with their green cards, even lawful permanent residents. Yeah, all right, great. Even individuals that are lawful permanent residents, even individuals with their green card will have these A numbers, alien numbers. Up until you become a citizen, you have an A number if you have any contact with any sort of immigration agency at all. This is an important identifier because there are certain features of the sort of immigration court system that you can take advantage of if you know the individual's A number. For example, actually, the past couple weeks it's been down. Department of Homeland Security has some technical problems since the 12th. So not maybe right now, but eventually there is a hotline, the immigration court system. It's housed under the Department of Justice. So prosecutors are DHS, the court itself is Department of Justice. There's Executive Office for Immigration Review.
Executive Office for Immigration Review, EOR is the acronym. They have a hotline where you can call the hotline, enter in the individual's A number, and find out things like the next hearing date in immigration court, decisions in prior cases, and various other information. So that's one way that the A number can be very, very important to figure out when the next time an individual has to appear in immigration court is the main one. In addition, if you're dealing with someone who's been detained by ICE, Immigration and Customs Enforcement, again, is the agency that plays the sort of enforcement role. So they're both the sort of arresters, like the cops, and they're also the attorneys, like the prosecutors. So from an immigrant advocate's point of view, they're sort of like the bad guys. But ICE has powers to detain certain non-citizens, and they have a feature that is called the ICE Detainee Locator. You can just Google that. It's available online because there's these various ICE detention centers all throughout the country, often in sort of far-flung, hard-to-reach places. If you're dealing with an individual or a family of an individual who's facing removal and has been detained, it's very hard to sort of track the movement through the system unless you have the A number, because if you do, you can use this ICE Detainee Locator. So in Virginia, there's this place, Farmville, maybe of you might know, where they house immigrants. There's some other big detention centers, a big one in Louisiana. Like I said, these are very sort of far-flung, hard-to-reach places, and without the A number, you have a very hard time tracking the individuals because so many people move through this system. So that's the A number. Going down, these first three check boxes here are important because they sort of describe the context in which this individual, the non-citizen, finds him or herself. We see here this says, you have been admitted to the United States but are removable for the reasons stated below. So this is a perfect example of what we're talking about. We're talking about people who are in this country but have committed crimes and are now facing removal. Removal and deportation, by the way, are sort of interchangeable now. Technically it's removal, but deportation, deportable is also another way to speak about these things. But you're removable for the reasons stated below. And below, we get through this 1 through 4. These are the factual allegations levied against the individual by DHS, by the prosecutors. So we see here this individual, not a citizen or national of the United States. Again, that was the first point I made. The important thing in this area of law is to figure out the immigration status of the person that you're dealing with. If you've got a citizen of the United States, you don't need to worry about any of this. On to whatever you need to do to just get the criminal side of things figured out without worrying about any immigration consequences. That's why most commonly in these notices to appear, the first factual allegation will have to do with the individual's nationality. So you see here, this individual is not a citizen or national of the United States, and point 2 says that he or she is a native and citizen of Peru. So we're dealing with a Peruvian here. Number 3, you were admitted to the United States at Miami, Florida on or about February 8th, 2002 as an immigrant. This means something in particular. This actually means that the individual has a green card, is a lawful permanent resident, because if you're admitted as an immigrant, you come with a special type of visa that results in you getting your green card. So you are a lawful permanent resident just one below becoming a citizen, and actually on the path to citizenship if you choose to go through the naturalization process once you become eligible. So again, that goes to the myth that people with green cards, lawful permanent residents, can't be deported. They certainly can, and often are, sadly. I saw a hand. Yes?
Are you saying that the term immigrant is exclusive to people permanent residents?
If you're admitted as an immigrant, yes. The risk of getting a little bit off topic, that this person was admitted into the country with a special type of visa called an immigrant visa, which means that a family member who was a citizen or lawful permanent resident petitioned for this individual to come and get his or her lawful permanent residency green card. So I perhaps just know this because I've been doing this for a while and know the context, but admitted as an immigrant means that you came with this immigrant visa and now have your green card. So this is probably not so important as the other stuff we'll talk about, but we do know here that this individual has his green card.
So if he came in on H-1B, what would it say?
Non-immigrant. The difference between immigrant and non-immigrant is sort of temporal. Non-immigrants are admitted, like in the H-1B contest, temporary workers. You're admitted for a specific purpose, for a specific amount of time, and you get this sort of alphabet soup, A, B, all the way through. I think there's like V visas, and that's just the way they're coded in the statute. So non-immigrant means someone who's here not permanently. Immigrant, permanent. So you've got the green card. That's also important because we know that a certain part of this statute applies to people who are deportable as opposed to people who are trying to come in and we want to keep them out, which has to do with admissibility, which, like in the evidentiary context, someone can either be admissible or not. And we'll talk about that a little in the next example, but we're focusing here on the grounds of removability rather than admissibility. So if someone's here, trying to kick them out. Number 4 is the biggie. So you were, on March 1st, 2006, convicted in the General District Court in Fairfax County, Virginia for the offense of assault and battery in violation of Virginia State Code 18.2-57. For that crime, a sentence of 12 months was imposed. This goes with the prior document we were looking at in the previous page, where we saw that the individual was found guilty of that offense and sentenced to 12 months. 8 of them were suspended. So you see here, this lays it out that the sentence here is considered to be 12 months, regardless of suspension, because it doesn't matter for immigration. We've got an individual guilty, 12-month sentence. Going further down on the document, see if I can maybe, it's bigger. On the basis of the foregoing, it is charged that you are subject to removal from the United States pursuant to the following provisions of law. Section 237, A2A, lowercase Roman numeral 3, Romanette, I think that's called, Romanette 3. That's kind of the excerpt that we were looking at before. That's the criminal grounds of deportability. And so this is saying this individual against whom the above factual allegations are levied is charged with removability under this section of our immigration laws. And this says that, if I could just sort of jump to the point, you've been convicted of an aggravated felony as defined in section 101A43F of the Act, a crime of violence. That's the example I was highlighting earlier. We've got a term in our immigration law called aggravated felony. It's got a specific definition. This gentleman has been convicted of a crime that's now, according to the Department of Homeland Security, classified as an aggravated felony. Therefore, he is subject to removal under the part of immigration law that says people convicted of aggravated felonies got to go. This is the charging document, so this is not the outcome. This is what they're alleging, and you can certainly argue this, and that's why immigration courts exist. But we know based on the factual allegations and the charge against the individual here that this is a pretty serious case, and this is involving, like I said, the worst case scenario, these aggravated felonies. So the individual may have very few, if any, options if it is decided that what's been convicted, the conviction here is an aggravated felony. Yes?
So I guess I have a question in terms of the sentence imposed.
Mm-hmm.
Is it a question of the maximum that could be imposed, or is it a question of what is actually imposed?
Well, see, that it depends on the context. We can look back here on, let's see, CLE 005. No, I'm sorry. 8. CLE 8. That's the aggravated felony definition. Again, it's worded weird. We've got this crime of violence subsection here under F. Crime of violence as defined in section 16 of Title 18, but not including a purely political offense for which the term of imprisonment at least 1 year. That has to do with the crime. So you look at the elements of the crime, what could be imposed. This gentleman actually did receive a sentence of 12 months, so we know that at least at a maximum it could have been 12 months because that's what he got. But you need to look at the elements of the particular crime. So in this case, it's this Virginia 18.2-57. So this is why it's so complicated. You've got 3 levels working here. You've got immigration law, then you've got the U.S. Code of Criminal Offenses, crime of violence, and then you've got the Virginia law. So you're cross-referencing each of them, and you have to look at the elements to see what the maximum sentence is for 18.2-57. Anybody know?
12 months.
12 months.
Or you can all certs.
Or what?
Or you can all officers, you can see previous charge with the add officer, there's actually
And what's the maximum?
5 years.
5 years.
Yeah, with a 6-month mandatory minimum.
Okay.
Okay, so what if he was given the 6 months instead of the 12 months? Would he still be in the same position?
Yes, because the max was 1 year or more. So, you know, in other contexts, the sentence imposed matters. There's, as I was saying, an exception to certain offenses and convictions that depend very heavily on the time actually sentenced, but not here. With these aggravated felonies, you look at the elements of the crime and the maximum possible sentence. So, looking at this NTA, page 1, we see at the bottom, you are ordered to appear before an immigration judge at the U.S. Department of Justice at this address. Actually, it's right down the street. They moved the immigration court now. It's in Crystal City, but this was actually very close by, over by the Ballston Metro. This is the immigration court in Arlington, Virginia. The new one is, as I say, Crystal City, but before the gentleman can be removed from the country, he has rights, or due process rights, and can apply for relief from removal, which we'll talk about in the last section of today's CLE. But that little reference guide earlier that I mentioned, I kind of glossed over those 3 pages. That chart talks about some of the more common forms of relief from removal. So this guy's in a pretty bad situation, but he may be eligible for some form of relief from removal, some sort of defense to being deported. Yes?
Let me also say this guy's probably not in your office because an aggravated felony is required to be held without bond. So this guy did not probably show up. Vice took him into custody, issued an NTA. He's sitting in Farmville Detention Center, which is run by Immigration Centers of America. You may be $100 a day to keep him there in slave-like conditions. So they're not going to let him. So he's probably not in your office is the point. So relative to your office into your office and said, help my spouse. He's not there.
Yes, the detention issue, hesitated to bring it up because that's another thing we could easily spend a whole CLE on about the options for bond or not. And certainly these conditions you outlined are certainly open for discussion. Some people might feel differently about them, but yes, you're very, very right. Some people are subject to mandatory detention, this gentleman.
But, and also somebody comes in and they're discussing the possible plea to the charge, but say, look, I think I can fight this charge, I think I have grounded asylum, whatever. Again, knowing that there are mandatory conditions for detention, that will maybe determine, you say, look, buddy, we can plead out to this, but you're going to spend the next 6 months in jail fighting this, waiting for a court date, which the immigration courts in the way in which shut down nationally for 2 weeks. These things you gotta understand are completely different than the criminal courts you're used to working with. Things that are unconscionable in a criminal court context are routine in immigration court proceedings. They are slow, they are unresponsive, and they are maddening to deal with. So also, if somebody comes down on consult and talks about a plea, having that conversation of both, if you want to plead to this, remember you may be fighting the next part of your case, the immigration part, from a jail, far away from your loved ones, with limited attorney access, limited access to your family and friends, whatever. So it's an important thing to keep in mind when forming that criminal plea.
Yes, thank you so much. We talked about the duty of defense attorneys to advise individuals on the consequences in the immigration world. Certainly, at a basic level, we just want to talk about the potential for enforcement, removal, deportation. But if you also get to a point where you can advise on any potential for detention, that's great. That's sort of like tier 2. So I'm glad you brought that up and get people thinking about it. The gentleman in the back first.
They make it impossible to get a result. Following up on your point, they won't even honor a transportation order. I've got a guy in Farmville right now who's charged with 2 counts of felony drug distribution in Fairfax. I filed a lawful detention order, and when I filed it with the jail, they said, "Is he in ICE?" I said, "Yes." I said, "They're not going to bring him up. We'll serve it, but they're not going to bring him up." And it was served, and I didn't hear a word from him, and I still don't know what happened.
It's very difficult, not impossible, but you have to move heaven and earth to get it done. I've had transfer clients up in cases like that. It's very, very hard to agree.
I have some commentary about ICE, but let's forge ahead. Yes.
Hi. I would share that my experience has been somewhat different with and I have an exclusive immigration practice. My experience has been different. What I found is that if I form a pretty decent on-arm rapport with some of the deportation officers and the supervisors, they actually are willing to help. And I'm in the process now of arranging a transport for a kid that's came here when he was just a child. He's been in detention quite a while. So I'm in the process of doing that. But it does take a whole lot of pushing. It takes a lot of nagging and being the squeaky wheel. It really, it truly does. But it can happen. And I'll also make the observation that as difficult as mandatory detention is, what I see with criminal practitioners is they're so anxious that all the client wants to hear is when they're in criminal jail, all they want to hear is, when can I get out? When can I get out? And the criminal practitioner says, oh, I got you a great deal that gets you out. And what it does is it puts them away for a way, way, way long time. And with some of my clients, especially some of the younger ones, especially some of the ones that have drug issues, there actually are times when I've almost been grateful that they had mandatory detention. Not that I want them in jail, but that is a way to guarantee that they're not going to get in trouble again before they have their immigration court hearing. And so obviously if someone's eligible for bond, we go forward, we do a bond hearing, but in some of my experiences, and it's also giving some of my clients time to get help with their addiction issues while they're in detention. And so I'm not in favor of detention, I'm not saying that, but I'm saying there are instances where you have to look at the whole person and the whole client and say what's in their best interest. And again, when it's mandatory detention, I don't have any choice, but it could be the only way that they don't get in trouble that disqualifies them from all immigration.
Right. Thank you so much. Yes, I said I have some commentary about ICE, but you raised a good point that this is all about their people too. They're just trying to do their job. As every attorney here knows, there's always an opposing side, opposing counsel, and it's all about sort of making their job easier and being courteous. And so it's all very much dependent on the facts of the case, but you may very well, aside from the mandatory detention context, you may very well be able to get things done based on a relationship that you might have or some particularly compelling facts in the non-citizen's case. So yes, immigration detention is fascinating. Yes?
I'll also be happy to say that there are times when the way that I've gotten, the warden at an ICE facility to do something for my client when my client was being neglected medically is I've asked him how much he enjoys depositions. And so there are times that you have to be very, very hard too, and they do respond to that.
Right. Yes. Thank you for raising the immigration detention issue. It's vast, complex, fascinating, politically charged. It's a little bit outside of scope today, but yes, that adds another layer of complexity to this. Yes?
I want to get back to the warrant on 16 and 17. Just,
Okay.
They did a good job of crossing out facts. With the gentleman's report, this is the only record that's ever going to be there. Is that beneficial on the immigration end, the crossing out specific facts?
Yes.
Sometimes the judge just says amend on the back instead of crossing things out.
Yes. A more complex topic that we could discuss, and maybe would be right for another CLE, is how to analyze statutes that criminalize different levels of conduct within one statute. So, for example, you might have a statute that says murder. You've got the murder statute, but it's got all the degrees under one section. And so if you've got a charging document here and a dispositional document here that finds the individual guilty just of the section generally, but doesn't specify which degree, obviously that can be good and bad. Bad because you don't know if this person did the least degree or the most severe degree. But to the extent that you're able to put on these type of documents, particularly when it is the sort of least severe degree or level, and cross out the more aggravated factors, it's always a good idea, because when you do that very, very difficult analysis of a particular statute, if you can rule out more severe versions of the crime that violates that same statute, you're putting your client, the non-citizen, in a better position. Again, very, very complex stuff, sort of beyond this little primer that I'm providing here, but great point. To the extent that you're able to specify exactly what the person did wrong, particularly if it's not so egregious, all the better. Going back to the NTA, let's go forward to page CLE 19. It's the backside here of the NTA. This has the sort of warnings, and this talks a little bit about the sort of due process rights and obligations that individuals in removal proceedings have. Yes, someone raised the point that things that wouldn't stand in the criminal context happen frequently in the immigration court world. Maybe this will give you illustrative of that, but that's what the backside of an NTA, a notice to appear, looks like. Let's go on to the next page, number CLE 20. This is a sort of third set of documents here that we're going to talk about, and I want to go through this because it's just a criminal history check. You all probably have seen this if you're doing work here locally, if you're doing criminal work. This actually goes to your point. We've got a history check here that says, gentleman's been arrested for possession of marijuana. We don't know what that means. Was it 5 kilos? Was it an ounce? We don't know. And we didn't focus too much on the drug ground of deportability, removability earlier when we were looking at the section of the Immigration and Nationality Act, but actually quantity in the drug context does matter. So this is sort of very broad. This is obviously just a criminal history check, but if we go to the following page, that's the statute, CLE 21, possession of marijuana unlawful. Now, I was just looking at this, and I looked at it again on the way over, but I don't see any reference to quantity. Those of you that are Virginia practitioners, am I right on that? Is any amount. So,
well, it gets to the point that if you've got 20 kilos, it's not personal use. So you can bet they're not going to charge you with just possession.
Okay. So maybe the charge is instructive in sort of the quantity, even though it's not specified, is what you're saying. Okay. Well, important in the immigration context, like I said, because there is a very limited exception. I think it's 30 grams or less of marijuana, and the consequences aren't so harsh. So this is a good example of what the point you raised. If we're able to get on here, this is 5 grams, not 5 kilos, that would be helpful to this individual in the immigration context. Let's go on to page 22, CLE 22. This is another notice to appear for this individual. A couple points I'd like to make about this. A lot of it is the same. We've got the personal information here redacted. The first box is, oh, I'm sorry, I totally neglected to continue on here on the big screen. after Giovanni went to links to get it up here. I'm sorry about that. Hopefully you've been able to follow along while I've been rambling on. This notice to appear says that the individual here is an arriving alien. The other guy in the first context was given a notice to appear where box 3 was checked. You've been admitted to the United States but are removable. This guy is an arriving alien, so he is subject to a different set of criteria whereby his criminal conduct can have consequences. So he's not subject to the grounds of removability right now. He's subject to the grounds of admissibility. So I put this in here at the risk of sort of running afoul of the title of the section, which is all about deportability, but the concepts here are very similar. So suffice it to say for this individual, and as we'll go through, the circumstances are a little different, but it's still the same sort of thing you need to keep in mind. So he's an arriving alien. 212 is the section of the INA that deals with the criteria that apply to arriving aliens. Let's look at the facts, the allegations here. You are not a citizen or national of the United States. 2, you are a citizen, you are a native of Sierra Leone and a citizen of Sierra Leone. 3, you were on or about April 14th, 1994, convicted in the Fairfax County General District Court at Fairfax, Virginia, for the offense of possession of marijuana. To wit, on or about March 6, 1994, you were arrested and charged with being in possession of marijuana. It's a typo. A controlled substance in violation of section 18.2-250.1 Code of Virginia. So, this is another situation where non-citizens got immigration consequences because of criminal activity. Just so you know, I think here that this individual also had a green card and was coming back to the United States. So this again makes it a little bit more complex, but he was considered to be an arriving alien because he had traveled abroad and come back to the United States. So he's treated as if he were coming here for the first time to be admitted. That's why the grounds of admissibility apply to him. I say that because you noticed in the last NTA, it said on or about such and such date you were admitted, Miami, Florida, you were admitted as an immigrant. This has no information about being admitted with a certain type of immigration status, so my guess is that this gentleman already had his lawful permanent residency and was not admitted any time recently to speak of, but had simply exited and was now coming back. So again, another sort of wrinkle, but the main idea is he's facing immigration consequences because of this criminal activity. This one has a continuation page, so the following page, CLE 22. This is where the charge of removability is levied. Again, it's not that section we were dealing with earlier, the deportability section, 237. This is 212 of the Immigration and Nationality Act. You are an alien who has been convicted of or admits having committed or admits committing acts which constitute the essential elements of or conspiracy or attempt to violate any law or regulation of a state, the United States, or a foreign country relating to a controlled substance, as defined in Section 102 of the Controlled Substances Act. So this guy is facing consequences for this controlled substances conviction. So he is in this context because of something he'd done. We have that information from the criminal history check, and we've got the statute on the prior page. What we don't know, again, is the quantity. So he very well may be subject to, or eligible for, rather, an exception to this controlled substances ground of admissibility because the quantity is so small. We simply don't know. This is an instance where more facts would be helpful. More facts would be helpful. But again, this is all put in here just so you get used to the idea of seeing that these state documents can result in the issuance of these federal DHS documents, which are not good. We want to avoid this. So anytime at all you're able to prevent someone from having Virginia documents that look pretty egregious, anytime you're able to sort of plead down or take a longer sentence, as the gentleman in the back mentioned, that would be great because it'll make the immigration job much easier when you get to that point. Yes?
I'm curious, how frequently and whose responsibility is it to report state information?
Another interesting topic, the communication between local, state and local law enforcement and federal law enforcement, ICE. You all might have heard of Secure Communities or the 287G program. Something for another day, but frequently in jurisdictions there is communication between the local police and immigration officials, and it usually plays out like this. If Jonathan, am undocumented, and I'm driving, I get booked for a DUI, I get taken to the jail, booked. If my jurisdiction has one of those agreements with the feds, with ICE, when they fingerprint me in the booking process locally, my prints get sent to the database with the feds, and if they see a hit, which is someone who has no record of immigration status or has prior immigration violations, ICE is notified that the person is being held at the facility in Fairfax, and then that triggers a certain time period during which they can come pick the individual up, put him in that ICE detention that we talked about, and place him or her into removal proceedings. So it's all very much dependent on the jurisdiction and resources, but you'll probably hear a lot about those programs. 287G is a section of the Immigration Nationality Act, and Secure Communities is the sort of technology reference. So it depends, but very common. Yes?
So this particular individual, was he picked up at the airport, or when did he get granted? What
This says CBP, CLE 22. Let me go back. Oh. You can't really see right here. If you've got it in front of you here, you can see on the signature line, this Michael Harris, it looks like, on the signature. He's a CBP officer, Customs and Border Protection. So that's another branch of the Department of Homeland Security. Those are the border guys. Those are also guys at the airport. So very likely an airport. Yes?
So I was kind of piggybacking on that. I observed that it was a CBP officer, but it looks like on CLE 18, it's not clear who filled that out. So can both ICE and CBP fill out these notice to appear reports?
Yes, ICE, CBP, and there's actually yet another, what's that?
The USCIS?
Yes, they're actually usually the good guys. They're there to give out the green cards, and they're the ones that issue those naturalization certificates from page 1, but they too have authority to issue these notices to appear. Anybody in DHS, are those three of these. We're doing okay for time. Any questions right now? Because we can go through the last example that I have here. Begins on page, oh yes?
Just also related to this, for those criminal practitioners and somebody coming in on this issue, if somebody's in jail on a local or state charge, be aware that your first instinct that you talked about before may be counterproductive to the immigration situation, and it may be context where you don't want to bond that person out because they haven't what's called an ICE detainer, which means we post bond on Tuesday, immigration stopped till probably Thursday or Friday to come by and pick that fellow up, move him to a place where it's much harder to communicate with him, where he may not be able to appear for a later court appearance. So in terms of planning, if you undertake criminal representation of somebody who may have an ICE detainer, you can usually find that out from the jail. That's a real big red flag. You want to, at that point, I think, stop and figure out why there's a detainer on, because bonding somebody out of the local jail may be the worst thing you can do in the long term.
Agreed. That's right, yes. For those of you that do this type of work, what I'm about to say might mean something. For those of you who don't, ignore it. But the rule is that from the time that the criminal charge is disposed of locally, so from the time someone is released on bond locally, ICE has 48 hours to come. If someone, or in other words, the local law enforcement can hold the individual for an additional 48 hours on this ICE detainer. So if you pay your local bond, you've got your guy in the local jail, the clock starts, 48 hours elapses. It doesn't include holidays or weekends, so 48 hours. So what's today? Today's not a good example, Thursday. So Monday, guy's released on bond locally on Monday. He's not really released. He's here on this ICE detainer. 48 hours is sometime on Wednesday. If he's still there on Wednesday after the 48 hours have elapsed and ICE hasn't come, you've got a habeas option. And that'll be discussed, I think, in a later section, maybe in a different context. But so the interplay here is fascinating. A lot of tricky issues, and not practicing in this jurisdiction at the state level, I simply don't know how it really plays out here. Commonwealth of Kentucky was real bad. Yes?
On the flip side of that, if they just don't want to get convicted, they can go home. There's no habeas because they didn't prove that they failed to appear because they got deported. And they can never get a conviction.
Yeah, you run into some tricky issues because then if you pay your local bond and then you get out locally and then you're awaiting your trial or whatever, arraignment or whatever, but then ICE picks you up and then you end up being deported. If you paid your local bond, you're not getting that back. I mean, tons of issues, and then property, and just, it's a mess. The interplay between these two is very fascinating. So that's why we're trying to get basics covered today. Sorry, it's a lot of complex tangents. We're now on page CLE 24. This is again, we've got summons here, Virginia document. Let me do a little rotation here. Rotate. Okay, cool. The next couple pages are all the same guy. So this guy, you'll see same criminal activity too. So you see there sort of toward the middle, August 24th, 2004, use of vehicle to promote prostitution. Following page. Aiding prostitution, 2009. Following page. Transport a person to a place used for the purposes of prostitution. And this guy can't get enough. He is just all over it. So we've got 3 offenses here, 2004, 2009, and 2011. So this is the 2-sided document. We've got the citation to the statute here, the Virginia Criminal Code. Following page is the disposition. Pled guilty, tried and found guilty. Sentence, this is a little hard to make out, 30 days. Then we've got this date on the bottom here, December 7th, 2011. The criminal issue was disposed of. Okay, so he had 3 things. We don't really know the dispositions of the first 2, but here we know at least we got a conviction with some punishment. December 7th, 2011. This resulted in the issuance of a notice to appear. Surprise, surprise, one of these documents again. So, we can look at that and see what he's facing. Now, I put in this example first because it's just, maybe it's not funny, but it's kind of funny that this guy did this stuff, similar pattern and practice of behavior 3 different times, and it's actually the most recent activity, the 2011 conviction that resulted in the issuance of DNTA, but it could have been any of those criminal convictions or charges or pleas that resulted in this individual being placed into these removal proceedings. That a lot of times there's not too much rhyme or reason when it comes to determining what criminal activity might result in the issuance of an NTA. Sometimes you can kind of guess, but there's no, just like prosecutors here don't really have a duty to prosecute things they don't want to do, at the immigration level, it's all a matter of resources and priorities, so it's not a given really in any case. In this particular instance, it seemed like this guy was making himself known to the Immigration and Customs Enforcement, and the third time's a charm for our friend. So we're looking at CLE 28 here, the NTA. In the interest of having an example with all 3 boxes checked, you see this one has the second box checked. You're an alien resident in the United States who has not been admitted or paroled. This is an undocumented person, illegal immigrants. That's not really the politically correct nomenclature, but this guy is undocumented. So not admitted or paroled means he came in without any contact with an immigration official. So again, like in the last example, as opposed to the first example where the subsection of the statute that I excerpted and read to you a little bit earlier applied, the deportability grounds, this guy, because he was never technically admitted, faces those criteria that are admissibility and inadmissibility. So it changes the set of rules that apply to him that say he can be deported for criminal offenses, but the concepts are still very, very similar. So again, at the risk of going afoul of the title, grounds of deportability, this is actually grounds of admissibility. But again, you've got this document, you've got these facts, you're not a citizen or national of the United States, native of Honduras, citizen of Honduras, you arrived in the United States at or near an unknown place on or about an unknown date. Okay, so we don't know how or when the individual is here. You were not admitted or paroled after inspection by an immigration officer. Those two are sort of go hand in. Were, number 5, on December 7, 2011, convicted in Fairfax County General District Court in Fairfax, Virginia, for the offense of aiding prostitution or illicit sexual intercourse in violation of Virginia Code 18.2-348. So the gentleman, the third time he ran afoul of the Virginia Code, he was convicted at the state level, and the Immigration and Customs Enforcement issued him a notice to appear and placed him in removal proceedings. So they have broad discretion when and sort of how to issue these notices to appear. Some people are sort of served when they're in detention. You know, you hear about raids on houses or workplaces. A lot of people end up in removal proceedings because they get apprehended at the state level, you know, with this communication between local law enforcement and federal law enforcement. So it just varies, but the charging document here is key. So that's why we've got a couple of examples here. Second page, the following page is the continuation, the back side with these warnings. There's not too much on there. Page 30, though, we'll talk about the charges. Again, it's all very much dependent on sort of what set of criteria applies to the individual, and you can see it's based on the person's immigration status. If you've got no status, if you're undocumented, you've got these grounds of admissibility. If you're here, you've been admitted, then since the government is saying, okay, we let you in, but now we want to kick you out, it's a deportability. That's kind of a simplified way of thinking about it. This page cites the actual part of the INA, Immigration and Nationality Act. You can see he's actually removable for 2 reasons. The first being that he doesn't have permission to be here. He was never admitted or paroled, so that's his 212A6A. That's got nothing to do with crimes, because remember, immigration is all civil law, so just coming here and being here without permission is not a crime. It's a civil violation. You know, maybe re-entering after you've been deported is another story, but just being here, not a crime. This second one, 212A2A1, all these Roman numerals, our heads just spinning, but this says that this is one of these crimes involving moral turpitude. And I can tell you, to save you the research on all the various cases that have adjudicated whether or not prostitution offenses are crimes involving moral turpitude, yes, as you might imagine, they are. So this guy doesn't have much luck. You know, you could argue it, but that's a crime involving moral turpitude. It doesn't help him that when you're in these situations, your entire criminal history is on display. So the following page is sort of another thing for your reference. That is from New York. It talks about the various grounds of deportability, these grounds of inadmissibility, which got kind of woven in there. Sorry, that was a little tricky, but the eligibility for citizenship. These are all various sort of levels of screening out that you're facing depending on your various sort of immigration circumstances, and each one has its own set of rules, but the concepts are very much similar. So my section goes on for a long time, but the last part is sort of a gift. Immigration consequences of selected Virginia statutes is very handy, but it's not 100% reliable. A lot of you might have seen it, but you'll all notice that this is from October 2007, so it's the most recent there is. But it talks about various crimes at the Virginia level, and I don't know what I'm trying to believe this side is. Is it a crime involving moral turpitude? Is it an aggravated felony? Is it a crime related to a controlled substance? Are there other immigration consequences? What are some alternatives? So this is very handy. As I said, it's not a sort of 100% reliable document, but I encourage you to take a look at it. But again, the main message here is this is all stuff you need to do before anything really happens at the criminal level. Avoid these grounds of deportability because there are a lot of times very limited options that immigration attorneys would have in presenting any of those defenses from deportation, because these convictions could have serious consequences for non-citizens. So that's all I got. I don't know if there's more questions now, or we should sort of take a break and wait till later. Okay. Yes?
I just have one. In various places of the alternate pleas and practice tips, you suggest keeping certain facts out of the record of conviction. What does that term generally include, record of conviction?
It doesn't include police reports. That's the main thing to take away. It doesn't include police reports for immigration purposes. It includes, see, this is all where it's very much different by state. So you've got the plea colloquy. Some places have that. For example, this looks like in Virginia, the warrant of arrest has two sides, and sort of the back is the disposition. So it's sort of one document. So it looks for misdemeanors, okay. Then you've got sort of trial transcript, and then if there's any sort of judicial order, those all constitute part of the record of conviction. But the main place you want to keep facts out of are the things where the disposition is, because that's definitely going to be in there. I couldn't tell you specifically just because I'm sorry, I don't. Not. Right, yes, but know that the police report isn't required. And so if someone tries to introduce a police, I guess this would be more an immigration court thing, but if someone tries to sort of go beyond the record and introduce something like the police report, that's not going to fly. So you're in good shape. So say the worst stuff at the beginning of the police report stage, and then when you've got the disposition, limit the language as much as you can. If you've got a broadly written statute with a lot of different levels of degrees of severity, make it say, to the extent possible, the least severe. Thanks.